So to move to the next section, it's my pleasure to introduce Thomas Shea. Tom is the Director of Training and Technical Assistance at the New York Immigration Coalition, a wonderful organization that does so much work from advocacy to training. Before starting with the coalition in October 2006, Mr. Shea practiced for 10 years with the Catholic Legal Immigration Network Clinic. Mr. Shea represented naturalization cases and coordinated group naturalization processing workshops for Clinic in Washington, D.C. before transferring to Clinic's El Paso, Texas office, where he represented detained asylum seekers before the Executive Office of Immigration Review, also known as EOIR, the Immigration Court. Mr. Shea then transferred to Clinic's New York City office, much to our luck, where he represented non-detained asylum seekers and applicants for adjustment of status before the EOIR Immigration Court. Mr. Shea has developed training curricula for Clinic and represented on such topics as international adoptions, relief from removal, victims of human trafficking. Mr. Shea has lengthy experience training on family-based immigration law, citizenship and naturalization, waivers and exceptions to select grounds of inadmissibility, public charge and the affidavit of support, adjustment of status, relief and removal proceedings, and unlawful presence, sort of the alphabet of immigration. So I've attended many of Mr. Shea's trainings. We're very lucky to have him here today, so thank you, Tom.
Thank you, Liz. And I'd like to thank CUNY Citizenship Now for inviting me to speak here today. And I wanted to thank all of you for volunteering your time to do the call-in, because I think this is a great project. I think it's a great service to the community. And I wanted to thank you all for doing it. So today, my topic is acquisition of citizenship and derivation of citizenship. You just heard about naturalization through Maggie. She gave you a great presentation on that. Hopefully I'll be able to give just as good a presentation. The materials that cover my topic in your manual start on page 17. If you could pull out your manual, because I'm going to actually refer to the charts that are provided in the manual, but we'll start on page 17. So get through this. So there are certain times when a person who is born to either one U.S. citizen parent or two U.S. citizen parents, but born outside of the United States, that person might be considered a U.S. citizen or might be a U.S. citizen at the time of her or his birth. Now the provisions that dictate whether or not a person born abroad is a U.S. citizen at the time of birth is in the Immigration and Nationality Act in a number of different statutory provisions. We have them here from sections 301 through 307 in the Immigration and Nationality Act. And some of these cover collective naturalization for when Alaska and Hawaii were territories, and when they became states, everyone in those territories were collectively naturalized. But it also includes Puerto Rico, Guam, and the U.S. Virgin Islands. Like people born within those territories are U.S. citizens at the time of birth. But be aware that when someone acquires U.S. citizenship at the time of birth, whether or not they do often depends on whether or not they were born within wedlock or born without a wedlock. And it also depends on the physical presence of the parents inside the United States before the child was born. In order for the U.S. citizen parent to convey their citizenship to the child at the time of their birth, the parent generally had to reside or be physically present inside the United States for a certain period of time. Now, because this question often comes up, there's also a way to convey nationality from a parent to a child, and there are people who are U.S. nationals but not U.S. citizens, and generally they are people who are residents of American Samoa and Swains Island. Under the law, it's people who are residents of outlying possessions of the United States, and under the current law, outlying possessions of the United States really comprises American Samoa and Swains Island. if a child acquires U.S. citizenship, it happens automatically by operation of law. And I want to distinguish this from naturalization that Maggie just spoke about. With naturalization, the applicant for naturalization has to meet all these different requirements and file an application to become a U.S. citizen, to naturalize. With acquisition of citizenship, if the parent meets certain prerequisites in order to transmit their citizenship, this happens automatically to the child at the time of birth. So it's automatically by operation of law. So the person does not have to file an application to acquire U.S. citizenship. In practical terms, though, it could be years later when they're 55 years old that they want to get proof that they're a U.S. citizen, and then they file an application to obtain, for example, a certificate of citizenship. Or they could file an application to get a U.S. passport. So it's possible in your situation, if you're going to be answering calls, even though we're using the term acquisition of citizenship for children of U.S. citizens, a child, everyone was a child at one point, but they could be 80 years now, they could be 75 years old now or older, and they might have acquired U.S. citizenship at the time of birth, and they didn't know it. And it's not infrequent that a foreign national, but someone who was born outside of the United States did not know until they get to speak to you that they acquired U.S. citizenship at the time of birth. So to determine whether or not a child acquired U.S. citizenship at the time of birth, it's the statute that was in effect at the time of the child's birth that controls. Since the founding of our republic, there have been many different statutes that have controlled how U.S. citizenship is transmitted at birth. Therefore, depending on the age of the person now, there could have been a different law in effect at the time of their birth. So in order for you to better understand which laws were in effect at the time of a person's birth, it's helpful to look at the charts that are on pages 20 and 21 in the manual. Charts A and B deal with acquisition of citizenship. And I want to give a shout out here to the Immigrant Legal Resource Center in San Francisco, ILRC. They're the ones who created the charts that are provided in your manual. These are very helpful towards just providing a good reference to how someone might have acquired U.S. citizenship at the time of birth. And I'm actually going to, in a few more slides, I will be going through or walking you through how to read the charts. So it would be helpful to you if you get a call on this topic. All right, for the first statutory provision, for acquisition of citizenship, as I mentioned earlier, the law may differ or depending on whether or not a child was born in wedlock or a child was born out of wedlock. So for a person born outside of the United States and its outlying possessions to two U.S. citizen parents, in general, in order for that child to acquire U.S. citizenship at the time of birth abroad, one of the parents had to have had a residence in the United States or an outlying possession before the child was born. So that's just the requirement for someone born to two U.S. citizen parents. One of the citizen parents just had to have residence in the United States in order to transmit citizenship. Also still talking about children born within wedlock. A person born outside of the United States and its outlying possessions to one U.S. citizen parent and to one U.S. national parent who is not a U.S. citizen. The U.S. citizen parent had to have been physically present in the United States or an outlying possession for one continuous year at any time before the child's birth. Yeah. And then here, the next slide is the most important. This is the one that you would get the most questions about or the most calls about. So for a person born outside of the United States to one U.S. citizen parent and one foreign national parent, the U.S. citizen parent had to be physically present inside the United States for at least 5 years, a period or periods of 5 years before the child was born, and at least 2 of those 5 years were when the parent was over 14 years of age, 14 or older. Now, just so you're aware, there are certain exceptions for the physical presence requirement for people who served honorably in the U.S. Armed Forces or who were employed abroad by the US government, or who were employed abroad by certain international organizations as they are defined in the United States law under the International Organizations Immunities Act. In other words, if the person had been outside the United States but was serving in the US Armed Forces, or was employed by the US government abroad, or served or employed by one of these international organizations, then they might be able to attribute their time outside the United States as counting towards the physical presence needed by the parent in order to convey or transmit their citizenship to their child before the child was born. Now we move on to what gets a little bit more complicated for children who are born outside of wedlock. So for a person born out of wedlock to a US citizen father and a foreign national mother, there are many different hoops that the father pretty much has to jump through in order to convey citizenship to the child. So there has to be a blood relationship between the father and child. The father has to be a US citizen at the time of the child's birth, and that's in all cases. You know, in order to convey US citizenship, the parent has to be a US citizen in order to convey their citizenship, you know, at the time the child was born. The father has agreed in writing, unless deceased, that he will financially support the child until the child turns 18. And while the child is under age 18, the child is legitimated under the laws of the residence or domicile of the child, or the father acknowledges paternity in writing under oath, or paternity is determined by a competent court or other competent entity that deals with paternity issues in family, outside of family court. Now, still with children born out of wedlock, a person born outside of the United States and his outlying possessions to a US citizen mother and a foreign national father, then obviously the mother had to be a US citizen at the time of the child's birth, and the mother just had to be physically present in the United States for a continuous period of 1 year at any time before the child's birth. So you can see there's definitely a difference in how the law treats children who are born out of wedlock to a US citizen mother versus children born out of wedlock to a US citizen father. So I just point this out so that if you get a call, that you know that you could go to the charts A and B, and primarily chart B for people born out of wedlock, to get good reference information on this. And I'm gonna walk you through the chart so you know how to read it. But because this is so complicated, particularly for people who are born out of wedlock, I recommend that you not be providing legal advice over the phone, but this is something you could advise them on what documentation they could gather and maybe get them to one of the CUNY Citizenship Now offices where they can get good, clear advice on how to proceed or whether or not to file an application for a certificate of citizenship. So the requirements as to whether or not a person or a parent has conveyed US citizenship to their child depends, again, on whether or not the child was born within wedlock or born outside of wedlock, how much time the parent had been physically present inside the United States before the child was born. And these things have varied over time. So if you could look at chart A first in your, if we could just, I'm gonna walk you through this. So you can see chart A on page 20, I believe. For your manual?
Oh, you want me to check? Yes.
That's last year's manual.
Yes.
So if you look at chart A, and again, so it says at the top, chart A, determining whether a child born outside of the United States acquired citizenship at birth. If the child born outside of wedlock, see chart B. Please note a child cannot acquire citizenship at birth through adoption. So looking at the top row, step 1, select the period in which the child was born. So like when you're screening a person, you're asking for their date of birth. So then you would go down column 1, and there's the period of time. As I mentioned before, there were different laws in effect at different times during our republic, and so different laws had different requirements. So right now, if you go to the bottom row, this is the law that's in effect right now for acquisition of citizenship. The bottom row in the far left column, you see, for children born on or after November 14th, 1986. Then go back up to the top row, step 2, select the applicable parentage. So if you go down to the bottom row, see how there's 3 different sub-rows in the second column. If both parents were U.S. citizens, then you go to the third step, and you see what their physical presence requirement was in the United States. It said at least one of the parents, U.S. citizen parents, had resided in the U.S. or its outlying possessions. So it just had to reside. There's no specific time period that the parent had to reside in the United States. It just had to have resided in the United States before the child was born. Back to column 2, under the one citizen and one national parent. So if you determine it, I've never seen this, so I doubt you're going to get a call on this, so you don't have to devote much time to it. So if you go to the bottom row, it says one citizen and one alien parent, and that's the most common question that you'll get. That's the category of people that you generally get called about. So if you look over to step 3, it says the requirement for physical presence is citizen had been physically present in the United States or its outlying possessions for 5 years, at least 2 of which were after age 14. So again, this is for children who were born outside of the United States to a U.S. citizen parent or parents on or after November 14th, 1986. But if you look up at the next section, if you're looking at column 1, for the time period, it says children born on or after December 24th, 1952 and prior to November 14th, 1986. You might get calls about that too. So just be aware, to look to chart A when you determine that a person born outside the United States, born in marital union, and you know the date of birth, you could determine which requirements apply to the parent at the time of their birth. But you see for that time period before November 14th, 1986, for children who have one citizen parent and one foreign national parent, the physical presence requirement is that the U.S. citizen parent had to be in the United States for at least 10 years, 5 of which were after attaining 14 years of age. So it's different. There's more of a physical presence requirement for the U.S. citizen parent at that time. It's less now. Now, if you could take a moment to look to chart B on page 21. So chart B, again, for acquisition of citizenship, and this is dealing for children who were born out of wedlock. So if you look at the top, it says part 1, the mother was a U.S. citizen at the time of the child's birth. In part 2, the mother was not a U.S. citizen. The mother was a foreign national, but it was a U.S. citizen father at the time of the child's birth. So for part 1 is the chart or the section at the top. Again, in the left-hand column, for children, at the very bottom of the left-hand column, it says children born on or after December 24th, 1952. The physical presence requirement for the mother, if you look to the right, the mother was a U.S. citizen physically present in the United States or its outlying possessions for a continuous period of 1 year at some point prior to the birth of the child. So if a person was born to a U.S. citizen mother outside of the United States and was born out of wedlock, the U.S. citizen mother just had to have continuous presence of 1 year at any time before the child's birth in order for her to convey her citizenship to the child. Now we look at the bottom chart. Below that, part 2, mother was not a U.S. citizen at the time of the child's birth, and the child has been legitimated or acknowledged by a U.S. citizen father. So date of the child's birth in the left-hand column. You look at the bottom row is the current law. For children born on or after November 15th, 1971, you look at the requirements that the father must meet in order to convey his citizenship to the child. It says number 1, as I mentioned before, the child-father blood relationship has to be established by clear and convincing evidence. Number 2, the father must have been a U.S. citizen at the time of the child's birth. Number 3, the father, unless deceased, must provide a written statement under oath that he will provide financial support for the child until he or she reaches age 18. And number 4, while the child is under age 18, the child must be legitimated under the law of the child's residence or domicile, or the father must acknowledge paternity of the child in writing under oath, or the paternity must be established by a competent court. If the father has complied with these requirements in order to convey his U.S. citizenship to the child, then you go back to chart A, and look at again, and start out on the left-hand column and look at the date of birth and see which law applies under for that period of the child's date of birth, in order to determine whether or not the father had conveyed or transmitted his U.S. citizenship to the child. As you can see, it's very complicated. I would never answer these questions unless I have the charts near me. So it's very important to have access to the charts in order for you to have a good idea of whether or not someone could have acquired U.S. citizenship at the time of birth. So questions to ask when you're screening someone to determine whether or not they might have acquired U.S. citizenship at the time of birth. Well, obviously, the first bullet is pretty obvious. You know, if you determine, comes out that they were born outside of the United States, then you need to find out their date of birth. You need to find out whether or not they were born within wedlock, if they're married, in other words, if their parents were married at the time of her or his birth. You have to find out if the caller's parents were U.S. citizens and when they were U.S. citizens. Again, in order to convey U.S. citizenship, they had to be a U.S. citizen at the time of the child's birth. And you have to find out where the parents lived before the child was born, because you know now that the parents have to have meet certain physical presence requirements inside the United States before they can convey citizenship to the child at the time of birth. And you need to know the parents' dates of birth, because you know, under the current law, the parents have to have physically been present in the United States for at least 5 years. At least 2 of those were after age 14, so you have to determine the age of the parents in order to determine whether or not they've been physically present in the United States for at least 2 years over age 14. All right, some supporting documentation, and this might be helpful if you're not, if you cannot advise someone about whether or not they acquired U.S. citizenship, then it's a good idea maybe to advise them to try to gather documentation that could help them, that they could bring with them to one of the CUNY citizenship offices, so that one of the attorneys there would be able to, or another nonprofit that they have a list of, that they have another list of in the, not that I'm trying to make everyone go to the, I don't mean to be inundating the staff attorneys for CUNY, so please don't hate me. But it could be helpful to the caller if you advise them to gather certain documentation, that, you know, documentation of the U.S. citizenship of their parents, their birth certificate to prove the child, like the caller's date of birth, any evidence to demonstrate the parent's residence or physical presence in the United States before the caller was born, things like that. Evidence of the parents being married, or, you know, or to demonstrate that the caller was born within wedlock, things like that, that they could gather and then bring with them to a authorized nonprofit immigration legal service organization, or to an immigration attorney, or to one of the CUNY Citizenship Now offices. So here's some examples of proof of residence that people could gather. School records, employment records, military records, deeds, mortgages, leases showing residences, attestations by churches, unions, or other organizations. That actually connects to the very bottom bar. Affidavits of third parties who have firsthand knowledge of the events that they're trying to attest to. U.S. Social Security quarterly reports, U.S. Census records. This isn't an exhaustive list. These are just some ideas for you about gathering documentation. And I just want to point out here, very often how this comes out is that it's someone who is older on, it could be someone in their 30s, again 40s, 50s, or older, who did not know that he or she had acquired U.S. citizenship at the time of birth. And so even though they don't have to apply for naturalization, as I mentioned earlier, they want to apply for a certificate of citizenship. And very often, it could be difficult to do that if you can't gather the supporting documentation, particularly about residence, physical presence of the parents. So if the caller is 55 or 60 years old, and then they have to go get documentation about their parents' physical presence in the United States before they were born, before the caller was born, you can see that that could be a difficult thing and could be time-consuming for them to track down. I'm not saying it's impossible, but I don't want you to think that it's like a slam dunk, an easy thing to file an N-600 and get a certificate of citizenship for someone who might have difficulty gathering supporting documentation about the physical presence in the United States of their parents. So as I mentioned before, you file the N-600 in order to get a certificate of citizenship for someone who is claiming that they acquired U.S. citizenship at the time of birth. Since November 23rd, 2010, the fee for the N-600 is $600. You may get checks or money orders payable to the U.S. Department of Homeland Security. You have to submit 2 color photographs taken within 30 days before you file the application. And as I just said, this could be coming. It's not just necessarily children. We're not necessarily talking only about children under the age of 18. We're talking about people any age now, as long as their parents had completed the requirements before the child was born outside the United States. As it stands right now, you don't file through a service center yet, you file through the local office. Now the next topic is derivation of citizenship. So I just finished talking about someone who was born abroad to a U.S. citizen parent or U.S. citizen parents, whether or not they acquired U.S. citizenship at the time of birth abroad. Now I'm talking about someone who was born abroad but might become a U.S. citizen at some point later on in life. So I'm specifically for this presentation talking about the Child Citizenship Act or derivation of citizenship under the Child Citizenship Act of 2000. That became effective on February 27th, 2001, and we're really talking then about people who were born on or after February 28th, 1983. And you might want to write that down because that might be helpful for you if you get a call, because this is the current law in place with respect to derivation of citizenship. So we're really talking about people who were born on or after February 28th, 1983. So prior to that date, there was a different law in effect that had as a more onerous requirements for a person to derive U.S. citizenship. And so just similar to or just like acquisition of citizenship, we provide a chart from the Immigrant Legal Resource Center in your manual, Chart C, on page 22. And I'm going to walk you through that shortly also, that lists the different time periods during which there was a different law in effect for purposes of a person deriving U.S. citizenship in the United States. So there just hasn't been one same law during the history of our republic. And similar to acquisition of citizenship, when someone derives U.S. citizenship, it happens automatically by operation of law. You don't have to file an application to derive U.S. citizenship. And similar to acquisition of citizenship, it's a matter of someone later on wanting to get proof that they're a U.S. citizen, so they file the N-600 to get a certificate of citizenship, or they file an application for a U.S. passport to get proof that they're a U.S. citizen. And this is also helpful to touch back on something that Maggie and Liz had mentioned before about criminal records, and with naturalization, Maggie talked about good moral character. With acquisition of citizenship and with derivation of citizenship, there are no good moral character requirements. You have to meet these specific statutory requirements in order to derive U.S. citizenship or to acquire U.S. citizenship. And if you've complied with them, then it happens automatically by operation of law. And this is helpful because if it's not infrequent that someone might be who thinks that he or she is a foreign national and has committed some crime and has been put into removal proceedings, then finds out that they might have either acquired U.S. citizenship at the time of birth or might have derived U.S. citizenship while they were still a child and they didn't know. And this is relevant because only foreign nationals could be subject to removal from the United States. A U.S. citizen and a U.S. national cannot be deported. So unless they determine that there was fraud in obtaining U.S. citizenship, fraud in the naturalization or obtaining U.S. citizenship. But therefore, if someone derived U.S. citizenship automatically by operation of law or acquired U.S. citizenship automatically by operation of law, and they don't know that till later on, if they can prove that during removal proceedings, they can terminate removal proceedings because they prove they're a U.S. citizen, they're not subject to removal. So under the current law, under the Child Citizenship Act of 2000, a child is someone who is unmarried. So we're always going to be talking about that in terms of the Child Citizenship Act and generally under immigration law too. A child is someone who is unmarried and under age 18 for derivation of citizenship purposes. So the child could drive through a parent, one parent who naturalizes or is a U.S. citizen. The child must be under age 18 at the time the parent naturalizes. The child must be admitted to lawful permanent residence. In other words, they have to be a green card holder, and they had to obtain that status lawfully. And the child must have resided in the United States in the physical and legal custody of the naturalizing parent. Now, one thing to be aware of, similar to acquisition of citizenship, the law treats children who are born outside of wedlock differently than it does children who are born within wedlock. So for these requirements right there, it's fairly straightforward. And again, this applies to children who are born on or after February 28th, 1983. And and it all has to happen before the child reaches his or her 18th birthday. That they've obtained lawful permanent residence before their 18th birthday, their parent naturalizes before their 18th birthday, they remain unmarried while they're under age 18, and they are in the physical and legal custody of the naturalizing parent or the citizen parent in order for them to derive U.S. citizenship. The requirements are different if the child falls under the last qualifying event occurred before February 27th, 2001, the effective date of the Child Citizenship Act. And I'll show you shortly as we walk through Chart C, there are more onus requirements in order for someone to derive U.S. citizenship before the Child Citizenship Act went into effect. And I'm just bringing this out here because you could get calls from someone who might have derived U.S. citizenship under the old law, under the prior law, before the Child Citizenship Act. It's not infrequent, that you might get that calls come in from people in that category. So, just so you're aware, in general, stepchildren cannot be treated, because the definition of child under citizenship, they're not treated as, or they're not allowed to derive U.S. citizenship. However, if they could be treated as adopted, or they are adopted under immigration law, then they can derive U.S. citizenship if they meet the requirements for adoption under the Immigration and Nationality Act. Now, under the Child Citizenship Act, when all qualifying events take place, regardless of which order of event they take place, then the child derives U.S. citizenship. Again, you do not apply for derivation of citizenship. You can apply later on for proof that you're a U.S. citizen, but it's not an application like naturalization. And then the law in effect at the time of the last qualifying act is what controls. So if you can take out, just look at Chart C right now from your manual on page 22. Am I hitting my time? Okay. So if you look at Chart C, which will be a helpful reference if you get calls, in the left-hand column, in the top row, it says date of last act. Just to be clear, what that really refers to is the date of the last event. There's different qualifying events, the child being a lawful permanent resident, child being unmarried, the child, the parent naturalizing, for example. So the date of the last qualifying event is what controls for purposes of the law regarding transmitting citizenship through derivation of citizenship. So if you go down in the left-hand column, each row refers to a different law that was in effect for purposes of derivation of citizenship in the history of the United States. If you go down to the bottom row, this is the current law in effect. This is the Child Citizenship Act, essentially. So in the left-hand column, anyone who, on or after February 27th, 2001, meets the following requirements is a U.S. citizen. So another way to look at it is anyone born on or after February 28th, 1983, and who meets the following requirements is a U.S. citizen. So then you would look over to the second column to the right, and A through G are the requirements that have to be met under the Child Citizenship Act for a person to derive U.S. citizenship before they turn age 18. So for A, at least one parent is a U.S. citizen either by birth or naturalization. And I want to compare that or contrast it. If you look at the next row up, For people, under the prior law, before the Child Citizenship Act, look at letter A, I apologize. Both parents must naturalize. That's different, so it's a little bit more onerous. Or, if only one parent naturalizes, the other parent must be either a U.S. citizen at the time of the child's birth and remain a U.S. citizen, or be deceased. Or the parents must be legally separated, and the naturalizing parent must have legal custody. So you can see already from the old law, much more onerous requirements in order to derive U.S. citizenship under the old law, as opposed to under the current law. So going back down to the bottom row, if you look at letter B, so in the case of a child who is born out of wedlock, the mother must be the one who becomes a U.S. citizen, or if the father is a U.S. citizen through naturalization or other means, then the child must have been legitimated by the father under either the law of the child's residence or domicile or the father's residence or domicile, and the legitimation must take place before the child turns age 16. So, in other words, if a child is born out of wedlock, in order to derive U.S. citizenship, if the child is born out of wedlock to a U.S. citizen mother, the child can't be legitimated by the father. But if the child is legitimated by the father, then the legitimation must take place, the U.S. citizen father, then the legitimation must take place before the child turns age 16 in order for the father to convey their citizenship to the child. The next requirement, C, the child has to be under age 18. D, the child must be unmarried. E, the child is a lawful permanent resident. And F, the child is residing in the U.S. in the legal custody of the citizen parent. Now for G, it's just to let you know, adopted children can derive U.S. citizenship if they meet the requirements of adoption under the Immigration and Nationality Act. So that's sort of like an add-on. It's not in addition to A through F. It's G is like a separate requirement for adopted children. So just to clarify, acquisition of citizenship refers to the parent transmitting citizenship at the time of birth abroad. So it happens at birth, and it's automatic if the parents meet the requirements. Derivation of citizenship happens after birth at some later qualifying event, either the naturalization of the parent or the child obtaining lawful permanent residence. So it has to be a combination of those. As with an acquisition of citizenship case, someone who derived U.S. citizenship can apply later on to get proof of their U.S. citizenship, and it's the same Form N-600. There's a fee of $600. For someone who's been adopted and they want to get proof that they've derived U.S. citizenship, the fee is only $550. And the other requirements for paying to the U.S. Department of Homeland Security and the 2 color photos are required also. So as supporting documentation, you provide proof of the citizenship of the parents, which might be a U.S. birth certificate, or it might be a U.S. passport, or a certificate of citizenship, or a certificate of naturalization, or an FS-240, report of birth abroad, because certain people who are born outside the United States can go to a U.S. embassy or consulate and get the U.S. consulate to issue proof that they were born abroad. You also provide the birth certificate of the child in order to confirm the child's age, and the marriage certificate of the parents to determine whether or not the child was born in wedlock or out of wedlock, proof of termination of other marriages of the parents, proof of LPR status of the child, which is usually a photocopy of the front and back of the lawful permanent resident card, and proof of legal custody in the case of divorce or legal separation. Now, as I already mentioned, you could apply either for a certificate of citizenship or a U.S. passport. And both documents are valid and conclusive proof of the person being a U.S. citizen. And I mention this here because it's not infrequent that maybe the Department of Homeland Security might contest whether or not someone did actually acquire U.S. citizenship or derive U.S. citizenship. And they sometimes question whether or not a U.S. passport that was issued correctly. And so they have indicated this, the USCIS has indicated this in liaison meetings, that if they think that a US passport was issued incorrectly, they will contact the DOS to have the DOS review the issuance of the US passport, and the DOS has confirmed that they have rescinded US passports when they determine that they've issued them incorrectly. I'm telling you this just so you could be aware that just because it's very important to gather the supporting documentation to prove all the elements, the US citizenship of the parents, the lawful permanent residency of the child, for acquisition, the physical presence requirements also, so that you can make sure that whoever files an N-600 is filing a complete application. And also for anyone who files a US passport application, that they're filing a complete application. Also be aware, locally, the USCIS has indicated that they have concerns about people engaging in fraud and filing the N-600s. So they do look at N-600s with a fine-tooth comb because they are concerned that people are engaging in fraud when they file the application, that they are in fact have not derived US citizenship or have not acquired US citizenship at the time of birth. So it's very important then to make sure to gather good supporting documentation to go with these applications. Also be aware that you do not have to file both applications, both a US passport and both an application for an N-600, but it's something to consider. If someone applies for a US passport but they have a record before the Department of Homeland Security that they're a foreign national, just because you apply for and are issued a US passport doesn't necessarily mean that the database with DHS will be updated. So if they can afford it, it's worthwhile to get a US passport and a certificate of citizenship by filing the N-600 also, because getting the N-600 will update the DHS database to show that your client is in fact a US citizen, just to help avoid problems in the future. And again, I know it's really up to the client, because if the client, it's expensive. You see, $600 for an N-600, and a separate fee. The fees, the information about applying for a US passport and applying for an N-600 are also in your manual. But I just want to point that out. And as I just mentioned, here's the authority. A valid US passport is conclusive proof of US citizenship and not subject to collateral attack in administrative proceedings. I provide the citations to that, and I just provide it here because I know it had been a problem in the past when people just applied for US passports and the Department of Homeland Security would say, oh, that's not good enough, we need a certificate of citizenship. So with that, I think I'm through with my presentation. So. Oh, yeah.
Thank you, Tom. Again, to illustrate how complex this area can be, I remember not too long ago at one of our naturalization events that was mentioned on the weekend, I met a man who was 47 years old and wanted to apply to become a US citizen through naturalization, the topic that Maggie covered earlier. And when we sort of started discussing his background and history, we discovered that he actually had derived US citizenship when he was about 15 years old. And he was incredulous that he's actually been a US citizen for over 30 years and had no idea, because no one, if you look at Chart C, he met that requirement, the more onerous one before the Child Citizenship Act was enacted, and no one called him and told him that, or called his mother, or even when his mother became a US citizen, advised her at that time that her son, who was listed on her naturalization application, automatically derived because he had entered with a green card and met all of those requirements. And as we talked about what the benefits are to being a US citizen, he could have applied for government jobs, he could have had a different life potentially. So I think it's really important to give context, because this is a complex area, and to sort of understand how it can be very confusing for folks, especially given how often the laws change. And I think even we all saw in the last election, there was some hotly contested citizenship issues. John McCain, for example, was born in the Panama Canal. So that was, that's the example I'm going to give as the hotly contested citizenship issue.
Can I add something too?
Yeah, please, please.
And I know it's hard. I apologize if my presentation was hard to follow. Normally when I give my own training on it, I usually have follow-up with like 2 pages of exercises, because for me, it was easier for me to understand the topic when I worked through it, and I was forced to take a practical case and walk through the charts myself to determine whether or not the parents had met the physical presence requirements for acquisition, and to determine whether or not like the child and the parents together had met the requirements for derivation. So I apologize because since I couldn't do that in this situation, like the time commitment with this, I couldn't do it. But I think it's very helpful to make sure that you have those charts on hand with you if you get calls, because it is very complicated. And even when I get calls, even now, I make sure I have them nearby for me to walk through it, because I just can't remember all the different requirements. And they change depending, as you see from the charts, there's different laws at different times. And you can get calls from people under different, that were impacted at different times in our history.
And I think the charts are a starting point as well.
Yes. Oh, I didn't. Okay.
We're going to invite Maggie back up before we start the Q&A. This is a great time for anyone who hasn't turned off their cell phone to do so now. I heard you ringing. I'm not going to call you out, but so just double check in case it was you. Oh yeah, there was one other point before we get the questions. Tom also mentioned the value of getting both types of proof, both the U.S. passport and the certificate. Two things to note. I know the fee is a lot, but you are also able, if you qualify, to ask for a fee waiver for the certificate of citizenship, number one. Number two, although a passport is much less expensive when you apply for it, it expires, whereas a certificate of citizenship never expires. So it's nice to have two pieces of proof for a variety of reasons. People lose documents, and it's much harder to replace them when you have no other, a backup, rather than collect everything all over again. So that being said, I think we're going to open it up to questions, both that have been submitted through the online mechanisms, I believe Facebook, the online stream or feed. I'm not sure which we're supposed to call that.
Okay, there's one other thing I forgot.
Oh yeah, no, Tom, go ahead.
I apologize. One other thing I meant to say, like, I understand that a common question or a common call that comes in with respect to derivation of citizenship anyways is that, oh, I just naturalized, did my child become a US citizen? So for purposes of derivation of citizenship, what you're looking at then is in chart C is what you would go to. For example, a man calls and he says he just naturalized, and he has, like, for example, a 10-year-old daughter, and he wants to know, did my daughter become a U.S. citizen? So that's, you start out right there going to chart C, and you go through the requirements in the right-hand side of the chart to determine whether or not the father met certain requirements and the child met certain requirements, because you have to determine whether or not the child is a lawful permanent resident. Was the child born within wedlock or out of wedlock? Who has legal custody? Because as I just went through, like if the father who just naturalized but the child was born out of wedlock, the father needs to legitimate the child before the child turns age 16. So there's different requirements. But I mean, just so you know, one of the common questions is, oh, I just naturalized, and I have a child who's under age 18. Did my child become a U.S. citizen also? And so the chart C would be helpful in determining whether or not the child did derive U.S. citizenship.
Thanks, Tom.